Next, we have Thaddeus Pope, who is going to be presenting on legal mechanisms to resolve futility disputes.
Good afternoon. So I'm going to address legal mechanisms to resolve futility disputes. And the first thing, and the most important thing to say about legal mechanisms, is that they are, and usually should be, a last resort. This sort of echoes Randy's comments earlier. Why? Because consensus is reached in most futility disputes. There's often, through communication and mediation, surrogates and providers can find agreement. In only around 5% of futility conflicts prove intractable. And in these cases, you should, even here, try to transfer the patient to another provider or facility that is willing to give the disputed treatment. Now, of course, usually such transfers cannot be found. Then what? Well, the first thing that I want to talk about, and the first thing that you should try or consider, is surrogate selection. And the basic idea here is that if you don't like the decisions that the decision maker is making, then find a new decision maker. Now, the job of a surrogate, whether the surrogate is appointed in the advance directive, by a court as a guardian or conservator, or as a default surrogate pursuant to the statutory priority list, is to follow the patient's instructions, if there are any, usually there are not, to exercise substituted judgment, and if you can't do either of those, then to make decisions in the patient's best interest. Am I making these advance by touching something? Okay. So now when the surrogate deviates from this job that they have to exercise substituted judgment, then the surrogate should be challenged. If the surrogate persists, then the surrogate should be replaced. And the law supports this. So take the easy case where the advance directive says stop, but the surrogate says go. So we had this case in Minnesota last year. So Albert Barnes had severe dementia, dependent upon ventilator, dependent upon dialysis, and was seriously declining. Had an advance directive that clearly refused the very sorts of interventions upon which he was dependent. But his wife, Elena, demanded these same interventions. So the hospital went to the Hennepin County Court in Minneapolis, and the court replaced Elena, who's both the wife and an appointed in the advance directive, with a professional guardian who then in turn consented to the proposed treatment plan. Now, I think that's the easier case. The tougher case is where you don't have a clear contradiction between what the surrogate is asking for and what you know is the patient's instructions or wishes. But it still seems that the surrogate's decision contradicts the patient's best interests. But even here, the courts regularly replace surrogates. Take this case from Massachusetts. Barbara Howe was at the Mass General with ALS for years. She was declining and had broken bones. They had to remove her eyes due to infections and so forth. And the providers thought that comfort measures only were appropriate. But her daughter would not consent. Now, in this case, the court didn't actually replace the surrogate, but clearly broadcast that it would, saying, look, your own personal issues are impacting your decisions. Refocus your assessment. And she got the message and then consented to the proposed treatment plan. Okay, so 3 comments about surrogate selection. First, it's already well established well supported in statutes and in cases across the country. And it's likely to grow because there's increasing scrutiny over the accuracy of guardian decisions and increasingly surrogate decisions as well. Second, you don't need a court or a judge to replace the guardian for you. Almost always you can do this at the level of the clinician or just at the level of the hospital ethics committee. And third, replacing the surrogate isn't just an option to resolve an intractable futility dispute, it's a duty. So right here in California, the Court of Appeals told the University of Southern California, look, the patient's son was appointed to the advance directive and had been demanding continued interventions, which the patient had clearly declined in her written advance directive. And so the court said, you should have challenged the surrogate, and if necessary, you should have replaced the surrogate. You shouldn't have kept doing that. The sister of the surrogate, daughter of the patient, had sued the University of Southern California. Now, there are some important limitations to surrogate selection as a dispute resolution mechanism. First, it's often unclear if the surrogate really is being a bad surrogate, really whether they're acting contrary to patient instructions, because it's not quite clear what the patient instructions are. Right? There are some black and white cases, but a lot of the cases are gray. Second, some surrogates are good. They're good surrogates. And an excellent example of this is the Hassan Rassouli case, which is now pending before the Supreme Court of Canada. Now, in Ontario, they have a special tribunal that regularly replaces surrogates in medical futility disputes. It's called the Consent and Capacity Board. But here, the physicians involved, Brian Cuthbertson and Gordon Rubenfeld, didn't take the Rassouli case to the Consent and Capacity Board. Why? They would lose. The family here, based on their Muslim beliefs, was making the very decision that the patient would have made for himself. They were good surrogates. There's no basis to replace them in the way in which surrogate replacement works. They're doing the job that they were supposed to do. And so the Supreme Court case is about whether or not clinicians can withhold or withdraw even without consent. And so that's the question I want to turn to now. If you can't get consent from the current surrogate or get consent from the new surrogate, then you might want to consider withholding or withdrawing without consent. And just to frame these legal options, I want to do that in the context, or framing that with a traffic light, red, green, yellow. The green light. The green light says, Doc, if you think it's inappropriate, you can stop. And you have immunity from any kind of sanction for doing so. And as Dr. Burns mentioned a minute ago, the main example of this, perhaps the only example, really is the 1999 Texas Advance Directives Act, which basically says, look, you may stop life-sustaining treatment for any reason, with immunity, is so long as your hospital ethics committee agrees. And this has been used in a lot of cases. Here's some examples of some. It's used quite a bit, and it's perceived as being rather effective. Indeed, it's seen as a model by many other states. And there's been efforts in all three branches of government to copy the Texas Act in other states. And so at the legislative level, medical society resolutions have asked for it repeatedly here in California, in Washington, in Wisconsin. In 2009, Idaho passed a bill substantially similar to the Texas Advance Directives Act. I think it was unanimously passed in the Idaho Senate, although it died in the House. In Maryland, instead of approaching at the legislative level, they're approaching at the regulatory level, and they're working on regulations now to to achieve the same thing at the agency level. And then in New Jersey, the Hospital Association and the Medical Society have sought a Texas-type law through the judicial branch, through an appellate court ruling in the Betancourt case. And similarly, of course, in Rasuli, what the physicians are asking for there is for a court ruling, basically saying that they have the right to stop without consent when they think it's inappropriate. But still, as of right now, Texas remains alone as a green light state. Now, it's important to mention that there's a second species of green light laws, conscience clauses, which have been very actively legislated over the past couple years. These laws basically say, Doc, you can refuse, not for professional reasons, but for personal reasons, right, based on your ethical or moral compass. Traditionally, these laws have had an important limitation, which is called a treat-till-transfer limitation, which is you can stop based on your conscientious objection, but not until you find somebody else to take over and treat the patient. But in some of the more recent examples of conscience clauses, in Mississippi, for example, this limitation has been eliminated. And there's some pending bills now, for example, in Oklahoma that also remove the treat-till-transfer limitation on a conscience-based objection. So what I want to do is I want to move quickly to moving from green lights to red lights. These laws, the red light laws, say that you must continue to provide the disputed treatment. Just a few weeks ago, in April, Idaho enacted a new law, effective in July. It's called the Discrimination in Denial of Life-Preserving Treatment Act. And it says health care may not be withdrawn or denied, if its provision is directed by the patient's directive, or by the patient's surrogate. Pretty categorical prohibition. Now, there is a fetal care exception to this prohibition, but it's pretty narrow. The exception only applies if death is imminent within hours or at most a few days, whether or not treatment is provided, or if the denial will not result in or hasten death. So it's basically limited to a pure physiological futility situation, which almost never happens, or imminent demise futility situation. And Idaho's not alone. New York basically enacted a red light in 2010, and there are pending bills in Oklahoma, which is very similar to the Idaho bill, which was enacted into law, and this has already passed and been voted out off the floor of one house of the legislature in Oklahoma. There's bills in Alaska, which is limited to CPR, no unilateral CPR, and in New Hampshire. Now, most places in the United States have neither a green light nor a red light, but they are yellow. It's just unclear in these cases whether or not doctors can stop the desired life-sustaining treatment without consent. And this is true even though many states have language in a statute, like California, like this, which says you may decline to provide medically inappropriate health care or health care contrary to generally accepted standards. And you have immunity for doing so. But these statutes don't work, and that's because of what was mentioned earlier, because there's significant variability, which makes it questionable whether or not there is any generally accepted health care standard, whether or not there is a standard of care, and therefore it's not quite clear where is the safe harbor that this statute purports to provide. Now, you can go ahead and stop life-sustaining treatment even without consent. Probably won't get sued. Surrogates are often grateful to be relieved of the burden of decision-making in a unilateral case. And even if you are sued, providers are overwhelmingly successful in these sorts of lawsuits. Still, the risk is not zero. There have been settlements, there have been verdicts, and even prevailing parties pay transaction costs in terms of time, emotional energy, and reputational damages. So, in the yellow light states, which is most states, most providers follow the substitute decision maker instead of doing what they think is appropriate. And so you might say that this is just another species of defensive medicine. And one measure, and I hope this is a good transition to you, Doug, one measure to combat defensive medicine in general, which could also apply here, is to develop clinical practice guidelines to help clarify exactly where that safe harbor is. Thank you.
Entertain any questions?
Alan Morris, Salt Lake City. I've often, thank you, and thank you for making easy to read slides. I've often wondered if much of this problem isn't our failure as a society to separate outcome from decision. It's clear that appropriate decisions can be followed by unfavorable outcomes and even inappropriate decisions by favorable outcomes. And in your own profession, the so-called ambulance chasers, you know, try and latch on to the unfavorable outcomes and make somebody responsible. Can you comment about whether we might be better off if we, as a social group, tried to emphasize more the difference between decision-making and outcomes? There are some that do that. The Israeli military, for example, separates outcome from decision much more effectively in many human groups, and they don't applaud or condemn people for a bad outcome if the decision-making seemed reasonable and appropriate given the information at the time.
I think that that's, I think that's a lot of what they were thinking with the Texas Advanced Directives Act, right? Which is, well, of course, they mandate it, right? But even in other states which follow the AMA model code from 1996, which is what the Texas Act is based on, if you have a careful process, you'll get deference from the courts, right? This is the same thing that the Healthcare Quality Improvement Act, right? So if you do a good job in your hospital with peer review and restrict or take away somebody's privileges, the courts will defer to the internal process. So I think that's right, and I think the medical profession's authority doesn't need to be usurped by the courts if there's a thorough, rigorous, transparent, and fair process that's handled intramurally at the institution. It is very likely to garner deference in a judicial setting, and should.
That I would argue, and I'd be interested in your perspective on this, that the bar for replacing a surrogate should be set very high. And to support that argument, I would cite the support study finding that when patients were asked if your surrogate says to do one thing and your advance directive says to do another, what should we do? And 60% of patients said, do what my family says, not my advance directive. And my understanding was that the courts were actually quite conservative, that it did require a court. You couldn't do this at the hospital or the ethics committee, and that the courts were quite conservative at replacing surrogates. Is that right?
I think that, well, if you look at published cases, and of course the thing about surrogate replacement cases is it's usually at a probate court, those aren't published, and so we have a disadvantage there. But in terms of published cases, there have been a lot more surrogate replacement cases in just the past few years. But absolutely good, on your very first point, yes, the bar should be very high, both for the reason you say, also because they should get some latitude and some discretion in how they interpret the patient's wishes and apply them to the facts at hand. And so I'm only talking about the outliers, the real outliers. And that's what we had in the cases at hand. Absolutely.
Are you able to go back through your slides to the slide on the pictures of the people where the Texas Advanced Directives Act was used? So I don't know if others noticed this, but if you take a look at the people in this picture, it looks to me like they're all people of color or women. And I don't know if you were trying to illustrate that this is a fair process, but I think a lot of people would argue that perhaps it's not a fair process to certain groups in our society.
Right. No, that's true, and I think there's been some studies in the literature by Martin Smith at Cleveland and somebody else that the Texas Advanced Directives Act has been largely applied to minorities. Now, what hasn't been shown is that it was because of, that there's a causal relationship between the minority status and the application of the formal Texas Advanced Directives process. And that's because, as you probably know, as everybody probably knows, that African Americans and Hispanics are far less likely to have an advanced directive, far less likely to accede to a recommendation to stop life-sustaining treatment. And so they're more likely to be the subject of a dispute, but it isn't necessarily because of their race. But there
They're
absolutely
more
is a
likely to
disproportionate
disagree with
impact.
us.
Absolutely.
Actually, in regards to that, there was a paper in the Journal of Perinatology about 3 or 4 years ago outlining neonatal cases that were brought up with the Texas Advanced Directive Act. And I wrote a letter to the editor that was published pointing this exact case out, that like 6 of their 7 were minority cases. So it's there. Whether or not you can establish causal relationship or not, it's certainly there.
You know what, may I, just to keep us on schedule, we have one more talk.